Welcome everyone to the first CIArb Qatar and UAE branches joint event on a mediation under the topic of mediation, some topical considerations. This is the third joint webinar Qatar section is doing currently. The first one was with the Egypt, the second one was London branch, and the third was UAE branch. And I hope that we continue cooperating with branches and specifically UAE. I will leave it now to our colleague Nurul to start with the introduction and the presenting the speakers. Nurul, please, the floor is yours.
Thank you, Saad. Good afternoon and good morning or good evening, wherever you are. Thank you for joining our first joint webinar between CIArb Qatar branch and UAE branch. So the topic of today's webinar is mediation, some topical considerations. So before we start with the webinar, so we would like to mention that unfortunately last minute, Jane, the president of CIArb, could not make it for today's event because she's unwell, and she sent her sincere apologies to everyone for the last minute inconvenience. So okay, I just want to do the housekeeping. So during the session today, so if there is any questions, please post the questions to the Q&A box. So this webinar will be recorded, and then we will share the recording after the webinar, and the Q&A session will be towards the end of the session. So for today's event, we are delighted to have three panels and one moderator. So the moderator is Thomas William. So the Thomas is a partner at a law firm here in Qatar, Sultan Al Abdullah and Partners. He is an English qualified barrister and leads the firm's arbitration practice. Thomas has been in the legal profession since 2002. He is an experienced advocate in arbitrations under all of the major institutional rules and in an ad hoc arbitration, and has also appeared regularly as an advocate in the English court and the Court of Appeal. Thomas has particular experience of complex commercial disputes arising in the fields of energy, oil and gas, banking and financial services, and construction and engineering. So without further ado, I'll pass the floor to Thomas to start the panel discussion for today. Over to you, Thomas.
Nurul, thank you very much indeed. Welcome and good afternoon, everyone. Before I start, I just want to express my sincere thanks to the Chartered Institute for organising this exciting event and for all the support that they've given to us to enable us to do so. Particular thanks, I think, to Nurul and to Saad. I'm delighted to introduce three speakers as foreshadowed by Nurul. Our first speaker is Robert Selinsky. Robert is an English qualified barrister and counsel at Al-Ansari and Company in Dubai. He specialises in contentious commercial and construction matters. He also sits as an arbitrator and mediator and conducts expert determinations. His presentation is titled An Overview of Mediation in the UAE, Challenges Encountered During Mediation, and Areas where Mediation Works and Does Not Work. Our second speaker is Hugh.
I think we lost Thomas. Maybe it's a connection issue or something. Thomas. Okay.
Try to get him on his phone, please.
Okay. So till we waiting for Thomas to come, can we start with the first presentation, please? Robert, can you start with your first talk to save more time?
Yes, of course. I hope my connection doesn't fail as well. Although webinars are a great idea and it's allowed us to continue throughout the pandemic and indeed with hearings and mediations. As we see, sometimes technology does fail us. Let's hope it doesn't happen anymore today. Anyway, I'm here to discuss with you mediation within the United Arab Emirates. Ultimately, mediation in the UAE has been around for a very long time. It's within the Arabic culture the Sulh, which means reconciliation. Now, although it has been in existence here in the UAE for a long time, commercially, mediation has not really taken off yet. You will find mediation being dealt with within family groups, perhaps, and certainly you'll find mediation, as we will see within the workplace. But commercially, mediation is something that has not really taken off. And there are reasons for this. Mediation is very important, and mediation should be used, in my view. Mediation does require confidentiality. Now, one of the big bones of contention over the years with mediation, probably in the GCC area, not just here in the UAE, was the fact that confidentiality was a problem, in as much as you don't have the common law concept of without prejudice. Without prejudice means that anything that's said in any discussion, negotiation, and within mediation in particular, remains within that negotiation and mediation, and cannot be used if there's a failure in that negotiation in any further dispute process. The whole idea, of course, is to allow the parties to be free, to say what they need to say, what they wish to say, and to be honest, without the fear of retribution for something they may have said at a later stage. Because, of course, should it go to arbitration or litigation, the reality is you don't want to have had all of your position given away before you've started. So without prejudice, mediation in the commercial world in the UAE has been difficult. So we needed to find a way to remove the suspicion of the parties about mediation. Trust in the process needed to be found, not only with the process, but also with the mediator, the person who is trying to bring the parties together. So what's happened over the years in the UAE? Back in, it sounds a long time ago now, but in 2012, there was onshore the Dubai Centre for Amicable Settlement of Disputes. This was actually tied to the Dubai courts. This was an attempt to encourage the parties to settle their disputes by using mediators. However, if a settlement was attained, that agreement had to be sent back to the court for review, and the court didn't have to accept that settlement was acceptable. So it was a mediation without the confidentiality in the way that we understand a mediation. And it was overseen by the courts, perhaps in a slightly more heavy-handed way than mediation in many other countries. Despite this, we did find mediation centres turning up in various offshore free zones within the UAE, such as the DMCC, DIFC, and ADGM. And in fact, the DMCC quite successfully uses mediation with workplace type mediations, where there are disputes between the employer and the employees. And it's been quite successful there. With the DIFC, you had mediation through the DIFC courts, but also through what was then the DIFC LCIA Arbitration Centre. As we know, that's now been taken over by DIAC. But the mediations under DIFC, LCIA, again, were very small in number. They weren't used in the way that I think most practitioners will have liked to have seen it be used. And the last one, the youngest, in fact, the ADGM, is certainly pushing mediation. And in fact, I was at an event there a few weeks ago where they announced mediation for investor-state disputes, rather, ICSID. And we now have an AGM and, along with CEDA, panel of investor-state mediators to deal with the increasing number of state-investor disputes within the region. So that's a positive step forward. But of course, investor state is not commercial in the way that we understand it, disputes between commercial parties. So how can we move forward? How can we encourage those within the UAE to use mediation? Well, to me, it's obvious that mediation is something that should be used. It's an effective and indeed an excellent way for parties in disputes to find a way forward without destroying their relationship, or at least hopefully not destroying their relationship, and without the very significant cost of litigation or arbitration. There are some disputes, of course, some very complex disputes, maybe significant value, extremely high, where the parties simply don't believe the mediation will be successful and therefore don't try mediation. But even those, I would suggest, should at least be tried first to try and resolve matters so that parties can move on. Another peculiarity, perhaps, of the GCC region, and certainly in UAE, is the fact that a very high number of businesses are family-owned. And so you get a lot of disputes with the family-owned businesses, which are perhaps unusual. They have a different dynamic. The most recent information I could find, although it's a few years old now, was PwC's Middle East Family Business Survey of 2016, which suggested that family businesses in the UAE contribute 60% to the UAE's GDP and employs some 80% of the workforce. So you can see that any disputes between family businesses could have a significant effect on the UAE itself. What are the stresses that come about in family business that perhaps you don't see in commercial businesses? Well, status of the participating family members, pride of as a family member in the business, in how it's run, and the succession in business, always difficult in a family business. These can create quite significant disputes where the different family members have a very different view on how to take matters forward, such that the commercial aspects that normally result in a dispute of profit, control and management are perhaps secondary to these issues. So family disputes in the UAE, I suggest, actually lends itself to mediation, where a soft hand approach is better than the heavy hand of litigation and arbitration to try and bring those family members back together again and find a way forward that actually doesn't end up destroying the business and indeed the family relationships. So mediation in that context, and I would suggest actually in any context, isn't a matter of winner takes all. It's not a matter of I must win at all costs. And certainly here in the UAE, with a large number of family businesses involved in commercial enterprises, I would suggest that finding a way forward within those businesses, if there's a dispute, is extremely helpful, and that mediation should be embraced. Clearly, with disputes between a family company and another family company, we go back to the usual commercial views of dispute and what is wanted: a breach of contract, we want damages, we feel we've been hurt in some way. That brings me on to the latest development here in the UAE, which is very welcome, I must say, the Federal Law No. 6 of 2021, the Mediation Law. What's important about this law is it's brought about a much needed framework for mediation with the UAE that was missing previously. The new law hasn't actually had much testing yet. We don't know if it's going to be successful, but in my view, it's a very positive way forward for dispute resolution within the UAE, which it is hoped will encourage commercial disputes to be mediated rather than simply turning to litigation and arbitration. Why is this a better framework, and why do I think it should work? First and foremost, confidentiality. Written into the law is confidentiality, Article 14 of the Mediation Law. in essence, what it says, that all materials, agreements, concessions made by the parties during the mediation cannot be used before any court or indeed arbitration, unless there's been prior approval by the parties to use any such material or concessions. In reality, what we're talking about is bringing in the common law concept of without prejudice into mediation within the UAE. If confidentiality is broken under the mediation law, depending who makes that breach, if it's one of the parties, it is potentially a criminal act. But if it's a breach by the mediator can also have repercussions, not only from the court, but from any mediation centre who has appointed him. So it's taken very, very importantly, and we should not be concerned about confidentiality under the mediation law. Other aspects that are quite useful, we have judicial mediation and we have non-judicial mediation under the law. Judicial mediation, as it suggests, is where a case has been commenced in the local courts, be it in the Dubai courts, and the court refers the dispute to mediation, usually by way of a party requesting mediation to the judge, and the judge, the court, agreeing and saying, yes, this is a matter that should be mediated. This can occur at any stage of the proceedings. It does not have to start and only be used at the beginning of the proceedings. Clearly, mediation is better to be used at the beginning of proceedings to try and keep costs to a sensible level, but it can be referred at any stage. Non-judicial mediation, of course, is where mediation is wished to be commenced by the parties prior to any litigation, any proceedings commencing. The parties will have had need to have a mediation agreement. That can either be part of their contract between the parties or a separate mediation agreement being drawn up. But you do need a specific mediation agreement. And that mediation agreement, along with your application, is sent to a mediation centre for processing. What does the mediation agreement contain? Well, it needs the subject matter of the dispute. Now, of course, you won't know the specific dispute that may arise when you're entering into a contract. So it needs to be reasonably widely drafted in the same way that you'd find in an arbitration agreement. You either need the name of the mediator to be used, set down in the agreement, or the process to be used to appoint a mediator. So you could refer to a specific mediation centre to process and administer the mediation. You would need to set out the language of the mediation. You will see, of course, a lot of this is very similar to an arbitration agreement. However, one important point here, should you, for example, decide to use English as your language for the mediation, because mediation is supervised by the Dubai courts, all paperwork should be translated into Arabic if it's in English, because of course the courts will be governing the process and may want to look at the papers that have been provided in the mediation. As to the application, straightforward again, parties' approval for mediation, the applicants undertaking to attend the mediation, all the relevant information required for the mediator should be provided, all the related documents, what is the actual dispute, a description of the dispute. If you're using what they call a special mediator, in other words, a non-court appointed mediator, that appointment needs to be set down. And perhaps slightly differently to many mediations in common law countries, the duration of the mediation that's agreed by the parties, or perhaps if it's court-mediated, court-run mediation, as the court has decided. So the idea that the mediation doesn't run on indefinitely. Other issues that are set down by the law, The mediator, of course, has to be a neutral person. There should be a list of official mediators registered with mediation centres, which a court can refer to when appointing a mediator.
Robert, sorry to interrupt, but we'll need to wrap up in the next couple of minutes.
Okay, that's fine. I'm quite close to the end. Thank you, Thomas. So wrapping it up as Thomas has asked, but the mediator, of course, cannot use anything he's learnt in the mediation outside of the mediation. He cannot give evidence against any party, and he can't act where he's related in any way to the parties. One interesting thing, costs cannot exceed 5% of the value of the dispute. So small disputes, small fee for the mediator. Settlement, if there's a settlement, has to be ratified by the court, who will then issue a writ of execution to allow it to be executed. One last point I wish to make, mediation centres. At the moment, there are some existing mediation centres, but they would need to ensure that they comply with the necessary permits and rules that are being set up. At the moment, we don't have any specific details of the licensing of mediation centres. So we have the hiatus. We have the law, but at the moment we don't have the official mediation centres. Anyway, that will no doubt be resolved soon. I think the law of new law mediation will take time to bed down, but I think it will be effective. And I think as judicial mediation is favoured by the litigants, or perhaps persuaded to by the judge, it will become more and more used within the UAE. And that, to my mind, is a good thing for the commercial world in the UAE. There we are, Thomas.
Robert, thank you very much indeed for that very informative presentation. And we're now on to Hugh. I think I did finish off my bio of him before I was momentarily cut off, and I even managed to set out the title of his presentation. So without further ado, Hugh Davis.
Good afternoon. I'll be discussing today an overview, or be giving an overview of the mediation provisions here in Qatar. I think by way of a background, it's important to note that Qatar has over the years taken a leading role in international mediation as a means of resolving or seeking to resolve international disputes. Arguably, therefore, you could say that mediation is recognised in the highest levels here in Qatar. At an international level, Qatar was one of the 46 countries on the 7th of August which signed the UN Convention on International Settlement Agreements resulting from mediation, or as is more commonly known, the Singapore Mediation Convention, which came into effect on the 12th of September 2020. Singapore mediation, I think, is important. It provides international recognition and enforcement for mediation-based settlements, which didn't exist before. And there are obvious benefits to various industries and countries who are increasingly turning to mediation as a means to resolve commercial disputes. If that's for purposes of maintaining a working relationship, or indeed, as referred to by Robert, the cultural environment where it's more appropriate to use a gentler form of dispute resolution as opposed to the arbitration litigation route. And again, I know Mr. Al-Ansari is on here on the panel, and he will no doubt have some views as to how Ashkal are approaching mediation, because I know they've given specific thought to that as a means of resolving commercial and construction-related disputes. In Qatar, I think there are two mediation procedures, the mainland and the Qatar International Court and Dispute Resolution Centre, QICDRC. I'll turn first to the mainland provisions. The mediation process, in Qatar was formalised on the 18th of October by Law 21 of 2021, which created a structure and a format for mediation in the mainland. Arguably, mediation did exist before because there's a requirement for employers and employees to resolve disputes by mediation, and the Qatar International Centre for Conciliation and Arbitration saw mediation as a form of conciliation. As I mentioned, mediation law prescribes what it applies to who, and on what basis the mediator can mediate. All three key concepts, I would suggest. Essentially, mediation can be used within the remit of the civil and commercial departments of the first instance court, which is a fairly broad remit, although certain categories are excluded from mediation. Urgent and temporary lawsuits being one example, another being instances where mediation as a process is specifically excluded. Of note, matters relating to Qatar Energy, formerly known as Qatar Petroleum, is another area which cannot be mediated upon. In relation to mediators, there can be one or more mediators appointed, so long as we maintain an odd number at all times. Whilst a mediator is to facilitate, as you'd expect, the law expressly prevents the mediator from imposing any solution on either party. This, of course, is reasonable, as it detracts from the purpose of a mediation. And accountability only arises as a result of bad faith, collusion, or gross negligence. The media, amongst other things, reassuringly, you might say, is to be fully competent, known for their integrity, impartiality, and expertise, and be of good conduct and reputation. And a mediation company providing mediators has a similar requirement. The mediator is to be paid notwithstanding the outcome. Again, this is important in different regions where there are different forms of payment, some only paying based on deliverables. Also, the parties are to seek all the costs associated with mediation if there is accommodation or a venue cost to be paid. Mediation must be in writing, otherwise it will be considered void in the mainland. And arguably, all mediations, I would suggest, should be in writing unless they're clearly simple and obvious to avoid any confusion and disagreements in going forward. The mainland requires a register of mediators, which is maintained by the Ministry of Justice, and you have to use a mediator who is listed on that register. As is becoming common practice in other jurisdictions, the court, as part of its function, will be asking parties as to whether or not they've considered mediation, and indeed will stop the proceedings and invite parties to mediate rather than pursuing the litigation. If that does happen and a mediation is arrived at, judicial fees paid and those which should be paid are dispensed with, as are any timescales relating to the litigation whilst the mediation is taking place. I think there's a clear shift of emphasis here to deal with matters in mediation in the mainland, as is the ability to deal with matters electronically. Mediation agreement, and Robert touched upon in the UAE. Interestingly, when a party refuses to abide by the mediation agreement, he's at risk of a fine being imposed between 1 and 10,000 riyals, which, as long as the figure doesn't exceed a quarter of the lawsuit's value. And there may be payment of up to 5 times the fees for filing the lawsuit. Mediation confidentiality is a critical element of all mediation, and its great importance is placed on it here in the mainland. Such being the case, there's a fine of 20,000 riyals or 25% of the value of the claim, whichever is the greatest, up to a maximum of 100,000 riyals. Timescales, again, are important. The mediator must accept or reject the set of instructions within 10 days, and the mediation must be completed within 30 days. One can understand that, of course, because there are both financial and operational consequences of a dispute, which ultimately is detrimental to the parties' relationship and their ongoing relationship. Having arrived at a settlement agreement, the mediator must write and commit the mediation agreement to writing within 7 days and file at the court also. Having been filed at the court considers as to whether or not it needs to be authenticated upon a request from the parties or the mediator, and it may either do so, and if it does that, the mediation agreement itself is beyond reproach. However, it should be noted that the court may refuse to authenticate the settlement agreement if it's of the view that it is in violation of the law or public order, was done by fraud or negligence, or if its subject matter is not permissible, or because it is impossible to implement one of its clauses. Again, I think an important principle here that when settlement agreements are written, that they're clear and workable. If I turn briefly to the QIC DRC, being mindful of time, and not as a plug by any way to Caroline Nicol or Carp Qureshi, but they in accordance with Sweden Maxwell, have published a book recently on the QIC DRC, which details the case law, procedures, and also has a chapter on mediation. QICDRC published a set of mediation rules in March 2020 and set up a mediation service in November 2020. The rules are supplemented by a template mediation agreement, and I'd advise any party instigating a mediation in the QICDRC to consider the template mediation agreement along with the rules as they supplement one another. Now, the rules of mediation agreement are as detailed as the mainland law, but I think it works in the QICDRC, and indeed it reflects the common law approach taken by the QICDRC courts. QICDRC's remit on mediation, therefore, extends to companies working within QFC and companies working within the QFZA, so the Qatar Free Zone Authority's free zones. So we've got a direct split: mainland, dealt by the mainland law, and then all QFC and QFZA companies dealt with under the QICDRC mediation provision. Currently, the QICDRC doesn't charge any users fees for using their facilities. The mediation itself can be initiated by the court or regulatory tribunal by contractual provision contained within the contracts or by a voluntary request. If it's a contract provision or a voluntary request, the parties will be required to write a mediation request to the court, which will be submitted to the register. Again, this form is available on the website. When nominated by the court or tribunal, the mediator will be nominated from the panel, QICDRC panel, of which there are 6 of us. Again, the mediators are listed on the website, and any viewer can read and decide if they want which one they want to use. By way of fees, parties to the mediation fees are responsible for the fees of the mediator, unless the mediator has been appointed by the court or regulatory tribunal, upon which the court or tribunal will then pay the fees of the mediator. Disclosure. The mediator is under a constant obligation to disclose any conflicts if it accepts a mediation under the QICDRC rules. And upon nomination itself, the mediator is required to provide a written declaration of its acceptance, availability, impartiality, and independence. Again, which I think is important, so that all the parties are clear that there will be no conflict and they'll have a degree of confidence in the individual appointed to mediate.
Thank you. Just one more minute.
That is fine, because I'm bringing it to a close there for you, Thomas.
Very grateful, Hugh. Thanks very much indeed. And our next speaker is Isabel Davis. Isabel is Director of ADR and Mediation Development at the Chartered Institute of Arbitrators. She's a CIDR accredited mediator and has experience of mediation in a wide range of domestic and international disputes involving matters including construction, commercial contracts, and employment. Isabel's presentation is titled Mediation from a Global Perspective and that of other jurisdictions, such as England and Wales. Isabel, over to you. Thank you.
Thank you, Thomas. Good morning, evening, and whatever the other one is, to all of you out there, wherever you're calling in from. I thought about this presentation, and the question that struck me, to use the phrase, is to mandate or not to mandate, and that is not the question. So the way that mediation is used or encouraged in different places around the world is very, very different. And the reason that I'm choosing to focus a little bit on the mandation idea is because what hides behind it is such massive diversity across the world. And it highlights some of the issues that I think where mediation is being introduced for the first time in the formal commercial setting, because it's rarely anywhere in the world, to be honest, being introduced for the first time truly, because in the vast majority of cultures, the idea of a third party facilitating agreement between parties rather than deciding for them what the outcome should be, is usually present in some form. But this diversity of practice around these formalized systems and how they interact with the court, I think is quite interesting from a comparative perspective, because it does highlight some of the decisions or the choices that are maybe being made more or less consciously. And what doesn't work. And one of the difficulties around that question of what doesn't work in terms of the introduction of mediation and encouraging people to use it is that, and this is one of the first points I would say, is that in many jurisdictions, the systems aren't put in place from the very beginning to gather data about how mediation is used and what the outcomes are and how people experience that. So I'll give an example of England and Wales, where there's often discussions amongst mediators and also comments from mediators that one of the good things about mediated settlements is that people are less likely to need enforcement. The mediation settlements are not necessarily going to need enforcement proceedings because people have voluntarily signed up to the agreement, which is of course different to an environment where there's an outcome that's decided in favor of one and against the other, where of course it's unsurprising that enforcement proceedings are very common. The difficulty is that in England and Wales, because of the way that the court system registers and logs cases that are decided through court or through mediation, even the schemes, it's almost impossible to follow whether cases have actually gone forward to enforcement, therefore making it impossible to track actually what the enforcement rates are. And I'll give you an example of how this international contrast can work. So I've recently discovered that in Nigeria, cases that have gone forward to mediation and reached a settlement are given a slightly different, are logged in a slightly different way, have a different sort of serial number, if you like. And therefore, it might potentially be possible to actually look empirically at what the actual settlement rates are. And that thing is quite exciting because we, as mediators, have lots of anecdotal evidence, as do people who are dealing with mediation, but it's about being able to actually show what's really happening. So I think that's also one of the reasons for looking to jurisdictions that are introducing systems of mediation into the commercial environment to encourage thinking about that at an early enough point that it's possible to consider how one might go about doing that, because of course there's many different ways. I think in the introduction that you've just received about the variation in Qatar and in UAE between the different laws, it again puts forward, even within one region of the world, how differently things are done, and also how similarly. So there are lots of similarities as well. One of the things which I've seen which does vary is the degree to which, in different contexts, even within one jurisdiction, the introduction of mediation is accepted as part of what I would call a sort of social contract. We do it because we think it's a good idea, not because anybody's forcing us to do it. And in other contexts, how it's very enforcement dependent as to whether people take it up or not. And sometimes there's also big differences in what people think is going to happen in relation to that from different interested parties. So an example, for instance, I was working as a mediator as part of the Central London County Court compulsory scheme back in 2004, 5, 6 time. And that was considered by some to be mandatory mediation, even though actually it was just an opt-out scheme. So every case that was referred people were offered mediation and they could say no, but you were automatically referred to mediation and you had to say, no, I don't want to go there, rather than automatically not going to mediation and saying, yes, I want to go to mediation. So there was no sanction, there was no compulsion in that sense, but it was still seen by some people as being a somehow forcing people. So I think this is one of the interesting things about to what extent just encouragement is seen as enforcement and to what extent it isn't. So I'll give a different example. The current situation in Ecuador in South America, where there's a high level of traditional dispute resolution amongst the indigenous people, the default system is that you go to mediation. And everybody goes to mediation first because that's what is socially expected and accepted. And that's quite an important point, because in different environments, depending on these things, you're going to have different levels of enforcement to encourage people. Now, I'm going to screen share briefly a little diagram, because one of the things that I've noticed looking at the way that mediation is introduced around the world is that what's often done is that a particular point within the journey from mediation to court is seen as being the point. And it's the sort of academic word is that there's a theory of contingency behind it, so that there's a right point to go to mediation. That's lost currency a bit, but this diagram will show you a little bit of just how many choices I think in reality that there actually are. So here we go. Here's a little diagram. And if you, I've realized maybe culture should have done it the other way around, but it does flow from left to right. I'll do another version flowing from right to left, maybe at some point. So on the left-hand side, this thin bar that you've got is everything that's happened before. So the commercial relationship that maybe has gone a bit wrong. And some people will choose voluntarily to go to mediation before they issue any sort of proceedings at all. It happens, and in some cultures, it's standard that it happens. In some contexts, before you actually issue your case, you are screened to check whether you have already tried mediation or not. So I'll give you examples of some systems like that that either say that you have to have mediated, or that you have to attempt a mediation information session before you even issue your case. So Singapore, India, Italy, and Greece all have situations that actually have very strong encouragement to mediate before you actually even issue your proceedings, and have different systems of checking whether or not you've done that. In other contexts, you get as far as issue, you can file your claim without having proved that you've already mediated. But at the point of issue, you then are often, in some jurisdictions, diverted straight into mediation on an opt-out basis. And those opt-out bases, or the reasons that you might be allowed to opt out, vary an awful lot in terms of what's acceptable. So Kenya, for instance, has recently introduced a system that means that almost everything, and the exemptions are really very, very narrow. So gender-based violence and child abuse are pretty much the only things that you're allowed to opt out of mediation. And you can't get forward into the sort of case management stage until you've been through that. Then at case management stage, you've got another set of systems that vary again in terms of how different countries deal with it. So the one of the most common is that by the time you get to case management, the judge or the clerk, clerk of the court, it depends on the system, may be saying, why haven't you mediated yet? And may have different levels of strength to be able to say, well, run along and mediate and come back when you've tried it out. Or you might actually go forward to a judge who then, and here again, there's variation between systems where the judge themselves, for instance, might mediate. That's the case in certain state courts in Germany, for instance. The judge may mediate themselves, or may send you off to mediation, which is the case in England and Wales, that a judge can, I think, technically not force you to, but it's fairly unusual if a judge says go and mediate, that people don't actually maybe follow that advice. And then, of course, there's the possibility to mediate right up to the point just before judgment. So one of the interesting debates that I was party to, again, back in the noughties, was when the discussion was going on in England and Wales as to whether there was any point in having a mediation scheme at the Court of Appeal level. And there was a lot of people who said at that point, well, there's no point in offering mediation at the point of appeal, because by that point everybody's invested too much. Nobody's going to go to mediation and risk losing it all. They'll want to go forward to court. Of course, that logic is somewhat problematic in terms of practice, because precisely at that point, people have often got an awful lot to lose, because they may have won several instances already, but may lose everything on appeal, and vice versa. They may have lost all the instances so far, and therefore feel that the chances of winning on appeal are maybe not quite as good as they think. So I suppose that what I'm encouraging here is to think a little bit more carefully about what we actually are talking about when we're talking about mediation, and encouraging the use of mediation, and at what point you can do what. Because the evidence from around the world suggests that all these different points that I've highlighted are points at which you can mediate. So rather than there being one contingent point that is absolutely correct, there are multiple different ways of doing this, that there's some need to align what are people going to stick to because the interest is very obvious, and where are there dissonant interests, perhaps sometimes between commercial parties and maybe between legal counsel in terms of how mediation is used and implemented, and therefore what is or isn't done at what point, and how sanctions, for instance, are designed in order to encourage the use of mediation. And just to give you an example, just looking across the world, I made a little list of the different sanctions that are used in different places. So not being able to file a case at all, for instance, if you haven't tried mediation, it's a sort of sanction for not using it. Not being able to move forward to case management if you haven't mediated. Striking out a claim is actually possible in some jurisdictions on the basis that you've demonstrated unreasonable behaviour by not mediating. Or a counterclaim. It depends on the jurisdiction. Again, there's the adverse costs order, which is a very common one, and sometimes a combination of the two things. So in some cases, in some countries, a case can be dismissed and adverse costs ordered because of the refusal to mediate. And I think all these things are really informative in terms of the development going forward, and particularly in view of some of the global developments, such as the Singapore Convention, because the ability to actually get a mediation settlement treated as a judgment and enforced around the world might, in principle, be much more important in principle than in practice, if we're right that actually mediation settlement agreements don't have to be enforced nearly as often as other types of award or judgment because of the mutual consent. But nonetheless, I think it gives a huge amount of assurance to people who maybe haven't tried mediation before and who haven't experienced it. So I think, again, that's something that is going to play out in quite an interesting way across the world. And I think that the diversity of different practices and experiences across your region is something which is really exciting at this point in time. And just as a very last
Isabel, 1 minute, please. Yes, thank you.
Just as a very last thought, I will just screen share one little diagram for literally 2 seconds to give you a sense of just how complicated that attempt to put the different routes into a graph actually is. And I'm going to stop sharing now before you all get eye ache, but just say you might have noticed in that brief time that Qatar and UAE are not yet on there. So I'm going to be reaching out to people to try and add those things in. But it is, of course, helpful to do that at the point where things are a little clearer in terms of how things are going to be put into practice. But there is a lot that we can learn from the global community that we have within CIArb, and I'd encourage you all to take advantage of that.
Isabel, thank you very much for that, and thanks to you all. I just want to come in, if I may, with a question straight to Isabel. I was interested to hear you talk about Kenya, and that struck me as pretty stark in the context of what the regime is in England. And you mentioned the Central London Civil Justice Centre and their pilot scheme in 2004, 2005. And that's when I was involved in doing litigation before the Central London Civil Justice Centre. And there was a misconception amongst lawyers that in fact it was a compulsory process. It wasn't. It was entirely voluntary, but it was put forward to the parties as something that they could consider. Now, in Kenya, if I understood you correctly, it's effectively mandatory. Now, that causes me some concern about access to justice, because what happens if parties don't want to mediate, they just want to press on with their dispute in circumstances where the real cost considerations, maybe people can't afford to go through a mediation process. Has that sort of issue been ventilated before the Kenyan courts, as far as you know? And if so, what was the outcome?
I can't give specifics. I've spoken to quite a few people in Kenya about that. I think my overwhelming impression is that the cost of going forward, you don't have to settle at mediation, so it's not mandatory. There are examples where, of course, we bump up against the issue of how
you don't have to settle, but you have to go through the process, right?
Yeah. So just to clarify, there are systems like in some areas in China, for instance, if you go to mediation, you also have to settle effectively. There's big questions around whether that's actually mediation at all, because there's so putting that's definitely not the case in Kenya, is what I'm saying. So all you have to do is enter the mediation, right? And the cost at that point of entering and trying mediation, as I understand it from the Kenyans I've spoken to, is so small in comparison to the time and length of going forward to court that proportionality determines that actually it still makes sense in terms of specifically the parties' needs. So I think it's also about overcoming some of the resistance amongst the legal profession to actually allowing parties access to justice by saying you can actually, so you don't have to wait for this long. And we have got an impossible backlog, which means that the cost, because as we all know, as the people interested in mediation, time and money are always connected. So if you look at one without the other, you never are seeing a true picture. If I offer to pay you £1 million, but say I'll pay it to you over 1 million years, its value is considerably less than if I say I'm going to pay it to you in a week. So the same thing applies to the costs of running a case. If you have to wait 10 years to get before a judge, then there's a different sort of cost involved. And I was talking to some people from India yesterday, and they were talking about exactly this problem, the absolutely inordinate cost of actually getting as far as the judgment means that the cost of actually mediating is still just incredibly small in comparative terms. There is a question, public policy question there, I think. Certainly in richer countries, I think in other countries, there isn't simply always an option because there is simply no money. But there's a public policy question of funding a justice system in a way that allows people to go to court in proportionate time. And if you can't do that, but that's an issue about public policy in relation to court.
That's a separate policy. Yeah, exactly. That's a separate question. But I'd be very interested to see whether access to justice arguments are ever marshalled, and if so, whether they're successful. But Isabel, thank you for that. I've got a question for Robert and Hugh, if I may. What do you see as the key differences from the perspectives of lawyers, parties, and mediators between the Qatari and UAE mediation laws?
Well, actually, as we
to have a go at that first.
Yeah, as we heard from Hugh, the laws are relatively similar, in fact. So I suspect the UAE law had a good look at the Qatari law in the first place before being drafted. But I actually think if the UAE process goes ahead as drafted and operates in the way that we all expect it to, it will be an effective mediation process. I think there's always a question mark if you've come to a settlement and it still has to be ratified by the court. Does that give the courts the option to say, well, actually, we don't like this settlement? But in reality, is that going to happen? There may be fears that, in fact, won't be, how can I put this, which are unnecessary and, in fact, will not be seen to coalesce. would you use Qatar over UAE? I think internationally, it would depend on where the parties' companies are, where the assets are, as always. And if you think that one particular regime is more useful in respect of your dispute than the other. But we are talking mediation. We're not talking arbitration. We're not talking about litigation. So mediation is really a bringing together of the parties, isn't it? To try and find a way forward that's not too damaging, that both parties can say, ouch, that hurt, but I can live with it. So
I think
I'd
agree with you there, Robert. And I think the other important thing is the appointment of a good mediator. Because regardless of the procedures, you need somebody to bring them together, enthuse the parties, and help them create momentum to cross the line, hopefully arrive at a workable solution.
Oh, absolutely. The mediator is vitally important. And that's where, certainly in the UAE, if you, at least court-appointed mediators, if they're going to be from lists of mediators held by the centres need to make sure that those mediators are actually very well qualified and excellent at mediating.
Yeah,
so training is going to be important.
That raises a question which many of our listeners might be interested in, which is how do you qualify as a mediator?
Well, you obviously go to the CIArb. You go to the Chartered Institute of Arbitrators. You go on one of their mediation courses. Actually, there are a number of very good training courses. CEDA, of course, was the originator for many people. Certainly, that's where I undertook my initial training as mediator. And the people like the Chartered Institute of Arbitrators actually follow very closely the CEDA method of training because it actually works. And it's all about not only making sure that you understand the potential problem, the commercial realities, but how do you go about bringing the parties together? You have to take your lawyer's hat off if you're a lawyer. It's not arbitration, it's not litigation, it's not about winning, it's about bringing the parties together. And it's a real skill that a mediator must have. So, yes.
I'd agree with you, but also...
Sorry,
just quickly, I agree with everything you're saying, and the baseline is done on training. But then, if you look at if I look at the Qatar, if you look at the criterion, there are certain criterion to act as a mediator, either in the QIC-DRC or in the state law. So, and there are consequences in doing that, either by way of professional reputation, and ultimately, when you think of it, in this case, parties elect the mediator. So the parties will know the mediators. Unlike, let's say, a court, where the system appoints the court, may not have experience. So ultimately, you've got a mediator who's been properly trained, who'll be known for his skill set by the users. And I think those are two important criterion. And reputation, ultimately for the mediator.
It's the same with arbitration, isn't it? It's when you're trying to choose the right arbitrator. And there are many good arbitrators out there whom we don't know about. How do we find out who they are? Yes, the court can appoint arbitrators, the court can appoint mediators. As you say, are they experienced? Are they good enough? The training is important. Centres making sure the mediators, or indeed the arbitrators, are good and are worthwhile. And where do you get that experience? Someone has to start somewhere.
Yes, it's a chicken and egg. I think given timing, I think it's important that we now turn to Ahmad Al-Ansari for comments that he would like to make.
No, I've got a question for the panelists. My question is, what is the main differences between mediation and conciliation? And what are the chances for a mediation process to turn into conciliations?
Hugh, do you want to, or Isabel, yes.
Just one word about that. I think one of the things that's important to bear in mind both about mediation and conciliation is that the way that the terms are used varies wildly around the world. So in some contexts, the two words are used completely interchangeably. So for some people, conciliation and mediation are exactly the same thing. In England and Wales, the usage is usually, but not exclusively, that a conciliator may make a non-binding recommendation if no agreement is reached by the parties. But that is just one version. In other contexts, a conciliation and a non-binding decision is expected rather than a possibility. So there's a lot of variation. So it's quite a difficult question to answer. In the one scheme that I've operated in, what I found was that in terms of expectation management, I would basically say an outcome that you reach yourselves is going to be better than a recommendation that I make, because you will have decided it. And I never actually made a recommendation in any of the cases I did under that scheme, because they settled as a result of the parties actually finding something themselves. But that may be an unusual experience. I hand over to the others.
No, I think I agree with you with that. It all depends on the terms of engagement, because there have been certain engagements where it said, look, if the parties don't agree, then the mediator will draft a report and the parties will accept it. So, yeah, it is a bit like if you look at ARB, MedArb, what works for the parties?
Well, it just happened out of my experience. I have mediated between a main consultant and a sub-consultant who happened to be an architect appointed directly by the Public Works Authority, Ashkal. We signed directly with this architect. It just happened at a point in time, the contract was novated to the main consultant. At the very end, both parties failed to agree the final account, and the row went on for about 6 months or 8 months. And then finally, I found myself mediating between the two parties. Very stubborn. I tried to calm things down between the two parties. I tried to help them to agree in a settlement. It didn't work. Finally, I said, look, this is what I'm going to do with you guys. This is my recommendation, and it's going to be binding. Take it or leave it. Otherwise, you'll never get any business with us. So they accepted. And I think it was a fair recommendation that they were happy with, but obviously they were trying to get the maximum during the mediation process itself.
Yeah. Ahmed, thank you. Before I ask you to deliver your closing comments, could I just float one thought for the panelists, which is this: I'm often asked by parties whether you'll get a facilitative or non-facilitative mediation process. And I say, well, it's entirely up to you. You can either have a mediator that is going to tell you on a confidential basis, maybe, or indeed sharing his views openly in front of the other side as to the merits or demerits of your position and the other side's position. Or you'll get a mediator who isn't going to go down that route and is simply going to act as a conduit, is going to go into the breakout room and say, well, what's your view on this? And then it's going to go to the other side's breakout room and say, well, this is what the other side say about your position. Has anybody got any experience of that, of the distinction between the two approaches, whether in your experience, clients want to go for one over the other?
Well, yes, over the years, I've tried both, quite frankly, trying to find what works best for any given situation. But you do need to have the agreement from the parties as to the format of the mediation that you're entering into, a bit facilitative or evaluative, whatever it might be. Because if they simply want you to be a facilitator, you shouldn't be stepping into the arena at all. Whereas if they want you to help to evaluate and perhaps discuss in a little bit more detail, even suggest, you need to have agreement for that. But I have found over the years that being an evaluative mediator actually works better. Parties are looking for a bit of guidance as to what their strengths and weaknesses are, of course, and as a facilitative mediator, you do that in any event, but also where you might see a settlement, even though you're not perhaps passing on at that point the other party's views. You, of course, have had those views, and you can use those views in a discussion with the other party without giving away the other party's position, questioning as opposed to telling, asking the right question to try and prompt the other party to think perhaps slightly differently outside the box of where they think they should be. So in answer to, sorry, Thomas, to your question, a bit rambling.
No, not at all, Robert, but let's wrap up and then we'll ask Ahmed to deliver his closing comments.
Indeed, they both work, but you need to be able to measure up the parties.
I absolutely agree with that. Yes, you've got to get everyone on the same page. Okay, Ahmed, thank you very much. Thank you.
Thanks, Thomas. Thanks to all panelists for this interesting topic. It was very interesting to all of us. Sorry. But as you all know, in this disruptive industry and disruptive supply chain and what's going on worldwide, globally, as we are all citing so many changes and instability almost all over the world and stable market conditions. So there is a great need now for alternative dispute resolutions rather than, classically going through litigation. And the nature of this market here in the market of the Gulf states in particular rely very much on litigation. Now, to change the mindset and make all parties concerned to a contract, whether it's a client or contractor or even consultant sometimes, to accept alternative routes. And we've been working on this for so many years, to be honest, and I still, to be honest, not fully satisfied with the progress we have achieved so far in this market, especially with the government clients. They are very stubborn. They do not accept alternative dispute resolution so easily, unless with very, very special arrangements, unless they get engaged with some high-tech holders and know-how providers. In niche industries, they find themselves forced to accept ADRs. So there is a great role on ourselves, to be honest, to educate, the concerned in this market to accept ADRs for, for the benefits they're going to get from that. I mean, mediation is a good example, to be honest. And beside that, we have obviously the other routes such as amicable settlements, or what I call it majlis style. Maybe those who work in this market do understand what I mean by majlis style, where seniors basically try to meet and with the concerned higher people here try to resolve things amicably rather than extending the process through endless process, to be honest, sometimes takes years and years. So thank you very much all, and I thank also Iryna for her cooperation with us, and I look forward to hold much more joint events between the Qatar branch, the UAE branch, and all the other branches worldwide. I look forward to seeing you in the future, inshallah. Thank you very much.
Thank you all.
Thank you. Thank you, Ahmad, for the closing remarks from the CIArb Qatar branch, and also thank you, Thomas, for moderating, and the speakers for their insights on the topic. So so I would like to invite Iryna, the chair of the UAE branch, to give her closing remarks. Over to you, Iryna.
Thank you very much, Nurul. And I think it all remains for me to add to what Ahmad has said. I wholeheartedly agree that these days users of ADR, commercial entities, commercial parties, litigants are increasingly looking for different ways, different tools, different options to resolve their disputes. And I will go even further to say, perhaps it's not just an alternative to litigation, but increasingly these days alternative to even arbitration, because as you all know, arbitration is becoming a lot more lengthy, expensive. And I think as many of the our panelists today have agreed, the purpose of options such as mediation is often not just to save costs or save time, and time is obviously cost, but to also, as Robert pointed out, is to keep the relationship going. It's very important, and sometimes that's the main reason why parties would consider mediation, for example. And indeed, as Hugh and Robert explained, last year, we've had both Qatar and UAE announcing the new laws on mediation, which again is a very important step in our respective jurisdictions. And I think it's a testament that there's a lot more emphasis, there's a lot more interest by the business community, and indeed the regulators here to put a lot more emphasis on use of mediation. And as Isabel said, in the UK, now consultations, I believe, are still ongoing, Isabel, if I'm not wrong. And I hope that UK will be joining Singapore Convention. UAE has announced a couple of weeks ago that it is going to sign Singapore Convention, and I'm very hopeful that the UK will follow suit. And I think that will only increase, yes, that will only increase confidence, encouragement for the parties. And indeed, I think you mentioned is also emphasis on the enforcement options. You know, you will feel a lot more confident that there is something such as Singapore Convention that's backing up your options at the enforcement stage. Not much from me to add. It was an excellent overview of mediation laws by both Robert and Hugh. So thank you very much for that. And Isabel has given lots of interesting examples of how mediation is used in different jurisdictions, and interesting you know, sort of sanctions there and fines that Hugh has mentioned, which honestly I was not aware of in Qatar, for example. So it's just to see how in different jurisdictions this very much varies, this mediation regime. But nonetheless, I think what's important to have as a takeaway from hopefully today's discussion is that the future is bright for so sort of watch the space, I should say. And indeed, as Robert said, the news on the mediators for the investment state disputes with ADGM is very much welcome development as well. The last thing that I wanted to mention is that, as all of the panelists said, skill set for any mediator is very, very different from that of an arbitrator or adjudicator, expert determinant, etc. So I think a lot more emphasis needs to be still done on training mediators, which, as Robert said, we all welcome you to join mediation courses of the Chartered Institute. We do run mediation courses, at least in the UAE and the UK. The question there, of course, remains how far the profession of mediators should be regulated. And I think today it's very much still self-regulated in a way. There are lots of different sort of institutions that train and accredit mediators. And the question, I think, is still open for discussion as to should we really have an overarching sort of body that will, you know, be sort of as a watchdog for the mediators alike. So all remains to say thank you so much to all our attendees that joined us today. Thank you to our panelists. Thank you, Thomas, for excellent moderation. And I should say that both Saad and Nurul were absolutely instrumental in preparing for this webinar. And Ahmad, as you said, we absolutely look forward from the UAE branch perspective to have more of those joint events in the future. So thank you all for joining us today.
Thank you.
Thank you so much. And hopefully we will see you everyone soon. Thanks everyone, Iryna, Ahmad, Thomas, Isabel, Robert, and Hugh, and Nurul, and also our friends and colleagues behind the scene who helped us preparing for this webinar from both branches. Hopefully we will meet you soon in another session for either Qatar or UAE branch. Thanks everyone.
Don't forget to thank the attendees as well. Thank you for you know, taking the time. It's Ramadan time. Normally, yes, afternoon people finish work, go to have rest before breakfast. Thank you very much.
Thanks for everyone. Thank you, Ahmed.
Bye.
Bye.
Bye. Thank you.